Couple new videos.
Couple of them, yeah.
And speaking of not dicks, Pat Darcy seems to have uploaded a couple videos as well. Just in time.
Yeah, he got did one on a little soft sit, another soft sit deal, and then I saw he dropped something a couple hours ago. So, all right, chat. How you guys doing? To answer your question, Yvonne, no, I haven't yet. I've got the card for it. I was going to go by the post office today, but I had to go to work for a little bit this morning, and just my day didn't allow it. But I'll go pick it up tomorrow. Hey, Script Cat, saw you were in early. Thanks for being here.
Hey, everybody. So, what's up? We diving into the video? Anything else on your mind?
Well, no, just gonna say hello to the chat and answer Yvonne's question there, and just looking at it, just breezing through it real fast, see if anything was brought up. Looks like everybody was just kind of saying hi to each other. So I say we just dive in and get the hell into it and go. Let me get it pulled up.
Yeah, there's a lot to wade through today.
Wallow in the mire.
Everybody get your hip boots on.
Yes, this is definitely deep. All right. This is the fucking title. This is going to be Chille claims that he's going to prove why he's falsely incarcerated and he should be released right now. And he's going to prove that.
Yeah, this is the Wilson, which is the first local case law he's found out. Yeah, this is I watched this one and then I watched most of the next one we're gonna watch. And man, it's probably good that I watched it beforehand because it upset me a little bit. But might as well go back into it.
Here we go.
Chille de Castro. Today is June 11th, 2024. I'm a journalist who's been unlawfully and unjustly locked up in the Clark County Detention Center in Las Vegas, Nevada. I've been charged with obstruction and found guilty by a biased, unprincipled judge who was married to a cop. It was the perfect trifecta. My lawyer didn't do a very good job.
Perfect trifecta. Yeah, he's woven the it's his usual intro, but he's added the little zestiness towards Zimmerman there at the end.
Right. He's what gets me is how ballsy
accusations.
He is.
What's that?
Well, how ballsy he is, because it's damn near threatening at this point, you know.
Yeah, I'd call it nerve less than balls or gall.
Gall, yeah. But it is somewhat threatening at times.
Yeah.
And the judge was biased, has been watching my YouTube channel, and she put me in jail for 6 months. I'm 3 months in. We are right now 4 weeks away. 4 weeks and a day away.
Chille complaining about somebody watching his channel.
Journalistic update is covering a case called Wilson versus First Judicial District Court of Nevada, February 8th, 2024. The case is based on a March 25th, 2021 arrest of Lena Wilson, Willson, when Sergeant Mike Cullen was called out to a scene where a juvenile teen was threatening to kill himself. Lena Wilson went out to her front yard and started to scream at the police. The police later would arrest her and charge her with obstruction. That's the short version of the story. If you want to read more, I'll have the editor put the full story up on the screen so you can read it. But now when I get to page 10 of the LexisNexis, she was found guilty by the court, and then it went to district court. They upheld her conviction, and then it went to the Nevada State Supreme Court. Now, I have an appeal in the district court July 10th, 2024, and so this is for the general public and any court officials who may want to listen to this. we have already had this exact obstruction case be heard in Wilson versus First Judicial Court of Nevada. And here's what it says on page 10. With respect to NRS Code 197.190 about obstruction, special intent would require that a person intended for a public officer to be hindered, delayed, or obstructed by the person's act. Now, that's what they charged me with, was obstruction. However, when I went on the scene in both of my cases, or I'm charged with obstruction, I announced that I was a member of the press and I was there to film them. In the second
All right,
case specifically,
right
I
there.
invoked my First Amendment right in the first one.
Again, he starts trying to use the press thing as a magic wand to get out of jail free card. And also Pat Darcy's here in chat, so welcome, Pat.
Hello, Patrick.
Did he just say LexisNexis too? Does that mean Chille has access to that? That's rather expensive. I'm assuming they wouldn't have access to that at the prison, would they? Or maybe they do. I don't know. At any rate, well, I think you can make an argument that Chille has, based on his pattern of doing this. And again, I think Zimmerman just sniffed it out early that he gets off on this. So I believe somebody could argue that he absolutely intended to hinder and delay him for his own whatever he's doing.
Absolutely. It's been his MO forever. It's not going to stop now.
Yeah. But then again, I've been watching the guy for quite a while.
Right. Well, I like the judge in the Hoyt Webb deal. I mean, he flat said to him, "You did this for your own entertainment, dude. You're not fooling me."
Yeah.
This has nothing to do with you being press.
Yep. Patrick, of course, you're welcome to come up too. If I don't know if Ram wants to send you.
Yeah, he's always welcome.
Wasn't expecting to see ya. It's always good to have you, though.
Yes,
I'm definitely interested. When should we play your video, Patrick? Before or after?
We'll do it after this. That way we can have a break on the Chille
Okay,
stuff.
sounds good. Well, then sounds good.
That's the way I've got it lined up anyway.
Cool.
That'll work, right? Can you believe that? It's actually organized. I'll have it all screwed up by the time we get there.
Minutes of interacting with the police. In the case that I'm in jail for now, unjustly, I also told them I'm a First Amendment auditor. It says here again, let me read it again for you.
Yeah, like that's a get out of jail free card too.
Intend for a public officer to be hindered, delayed, or obstructed. That was not my intent. My intent was to be obstructed by the person's act, whereas general intent would require only that a person intended to perform an act that results in the hindrance, delay, or obstruction of a public officer, regardless of whether the person desired such a result. Now, there's more. Inside of this Wilson case, there's about 8 paragraphs that my lawyer can read at the district court to Judge Michelle Levitt and to the court. This case has already been heard in district courts. They found Lena Wilson guilty. It went to the Nevada State Supreme Court, and here's what they wrote in another one. Because the term willfully may also suggest an evil or malicious purpose on the part of the actor, and the terms hinder, delay, and obstruct are transitive verbs that require a specific object, any public officer, the phrase willfully hinder, delay, or obstruct any public officer may also reasonably be interpreted as requiring that a person intended for their act to hinder, delay, or obstruct a public officer. Well, I already announced that I was the First Amendment auditor and I was a member of the press. So it wasn't my intent to hinder, delay, or obstruct.
Nothing.
It was my intent to be a member of the press. Continue on page 11. It says here, holding common law offense requires that the defendant intended his or her conduct and intended the harmful consequences of the conduct, and that is the interference with, obstruction, or hindrance of. Thus, to the extent that there is guidance from the other jurisdiction, it tends to lean towards
Ram.
the statute
Yes,
as
sir.
requiring specific
Did you send Pat the link?
I did.
Okay, cool.
intent.
Yeah, and I got a question for him. when he comes up for sure.
We'll take a little pause here.
Many questions.
Yeah, and I know Script Cat said this has all been covered, but the reason we're doing this again is, one, out of the horse's mouth, and two, it's what follows this has a little interesting twist to it too.
Yeah, and I believe it's at some point in here, it's kind of saying that, or it says directly, if I remember right, that it's basically saying that obstruction does not have to be physical, the intent, and that the intent is the thing.
Yeah, and I thought Judge Zimmerman hit on that in the trial when she emphasized that, just because there wasn't physical contact, you were interfering with his traffic stop. His attention was taken away from his job. If you take his attention away from his job, then that's interference.
Right. But then in the next video that we'll watch,
Patrick sounds like he's on the road.
Yeah,
Let me see
a
here.
little bit.
Hold on, I'm driving. Yeah, unplug this thing.
We could have a sing along with Patrick in his car. Put some good tunes on.
You guys hear me okay?
Yes, sir. Loud and
That's
clear.
working? Wow,
yes, sir.
Okay. Just here watching a lady walk her doggy. It looks like one of those corgis. Those are really cute dogs.
Yeah. My next door neighbor has a couple of them. They're good dogs.
Yeah.
I think I love dogs more than I love people.
I absolutely love dogs more than I love people.
Hold on a second.
All right.
Your dog is so cute. I love your dog. Oh, you're live on the radio too. Go ahead.
Nice.
Anyway.
So, yeah. Well, we'll.
You want to ask him, or you just want to go on?
No. I think it comes a little bit later. I mean,
gotcha.
we've established that. I think we can all agree that obstruction does not have to be physical, right, kids?
That's correct, Amundo.
Yeah, that's the thing that is the catch-all in the way that they changed the Wilson decision. Wilson also is basically admitting and capitulating that I was right several months ago, back in December, when I said that the statute as written was unconstitutional. And one of the ways that you look at a statute is how it is written. So I got a lot of heat from Chille supporters at the time. You never looked at the videotape. How dare you even comment on this? You don't know what you're talking about. And I'm saying, wait, I don't have to look at the video for this level of analysis. I just have to see how it's written and whether or not it would impinge on constitutional liberties. That's what I was doing. Then that Cap Failure guy who has that great channel with all the videos spliced together, I asked him and he said it would be okay. So I uploaded it onto my thing, and then I looked at the video to then look at the conduct to see what I thought about that. But Wilson is one of those rare instances where a statute that was written in 1911, which has no legislative history, and when you want to look at a statute and determine why did the legislature pass it, you look at legislative history, and it'll tell you the motivations behind the law. Anyway, the appellate court really couldn't find any, and they really couldn't find much in the way of an appellate history for it either. And so, hold on a second, my battery's low on this thing. Let me know if I lose connection. Am I okay?
Yes, sir.
Okay, good. I don't want the call to die. Anyway, they really couldn't find much in the way of that either. And so what they did is they tried to clamp down on the statute by making it a specific intent statute rather than a general intent statute. And so it also had the requirement for a lawful order. They've abolished that. That's some of the things that the cop said on the stand. I gave a lawful order, which is to put someone on notice. The big problems with the statute is still the appellate court is saying we can't write it to fit every situation. And so they made it specific intent. They tried to narrow it to physical conduct and fighting words, because fighting words is something that has already been defined anyway through case law. But, and here's the but, they've also said basically that passive aggressive behavior that would delay can still constitute physical conduct. So Chille mentions the exception in his video. He did see that, but I don't think he's applying it right, because
No.
if you act in a way that would hinder the cop's ability to do his job without fighting words, you basically remain silent. I mean, the best example I can give would be those stop oil protesters that don't say anything and they just lay in the middle of the roadway. I mean, if that isn't obstruction, well, what is, right? And that's their intent. They're not going to fight you. They go limp when you pick them up, and they do things that would constitute obstruction, even though, in this instance, if you just act in a way that has a purpose to it that would delay the cop and keep him from doing his job, that also will count. And I think that there's enough there to get Chille on that, because one of the comments that the cop made to him, irrespective of backing up, was something like, come over here, whatever he said, and Chille said no. Well, that's about as willful as it gets. And like I said back in December, willfulness.
Uh-oh.
Oh, yeah.
Uh-oh.
Yep.
You're starting to fade out, Pat.
Ping, ping,
assuming he's on his way home. So, did you want to dial in when you get home?
I hear background. Yeah, I hear him again.
Okay, so I said back in December was, willfulness will be the easy standard of all the standards to bust somebody, as opposed to subjective intent and everything. Because Chille keeps talking, that wasn't my intent. Well, it's looked at from an objective standard, not subjective. And when he said no, for example, well, now how is that not obstruction, right? And so the Wilson case is important, but and then again, we have to go to what is actually before the court for the appellate record, not outside the record, but what's inside the record. And what's inside the record is a 12-minute tape. Now, in California, we have a thing called a statute, I think it's 356, which is to allow basically rebuttal evidence. Like if someone is giving you a videotape and you say, wait, that doesn't paint a fair picture of what actually happened. So 356 will allow you to bring in evidence to rebut that, so that the jury or the judge would have the actual full information in front of them and not see something that may put everything into a false light. And hold on one second here.
Yep.
All the buzzers are going off. So you have that kind of stuff, and so they're only going to be looking at the record unless, since Forum has filed a motion to bring additional stuff into what they call augmenting the record. This would be a chance for the people to say, well, you know what? There's that video of Chille that he has posted, I don't know if he still does, where he narrates the actual arrest him and shoulders were above him and how the guy could fall on his head and, all that other stuff. Well, I mean, so it's kind of a dangerous thing when you start trying to augment the record outside of what is part of the record and going outside what's in front of the trial. But the reality is that these are party admissions that are made on a videotape where they're the two participants. So when people criticize me for not objecting to the evidence, I've been saying all along, there are other ways to get evidence admitted, okay? Especially when it's being narrated. Anyway, I hope I answered your question.
Yeah, that's what I was. Yeah, that was sort of what I was getting at. You could use Chille. My thought was you could pretty easily use Chille's video library against him.
Oh, absolutely. And that video is still up.
In establishing like intent or pattern of doing this, and
that was verbiage out of Zimmerman's mouth too. Pattern. She said that more than once.
So Patrick, he
dropped,
out?
but he'll.
Okay.
I'm sure it sounded like he was pulling up so at home. Or
Yeah, it sounded like he was getting home. So yeah, Pat, thank you first of all.
Absolutely,
the whole class thanks you again. Just dropping sheer legal knowledge on all of us. Appreciate it. And you're certainly welcome once you get settled and whatever. If you want to come back up, absolutely. So yeah, that was sort of my thought. I mean,
actually, chat. Just so you know, I think Patrick just got 3 free spins. That's what that noise was, or a couple extra balls on the pinball machine. I'm not sure which one it is.
Maybe he wasn't. Take over.
He wasn't in.
Pat's.
He wasn't in his car.
Maybe he's going to be taking over for Pat Sajak.
Pat Sajak. I thought that was what's his name from the singing show. Isn't he going to do something like that? Carson or no, the other one from American Idol. The DJ from out west.
Seacrest?
Yeah, Ryan Seacrest. Isn't he taking that job or something?
Sure.
Well, I don't know. That's what I saw. I don't know. I'm just telling you what I saw. I saw it in the news. Said Ryan Seacrest is going to be the new host of.
Yeah, he's the new Dick Clark. He's the new. Yeah, he's just literally a.
Yeah, I'm not advocating it or anything.
Stereotypical, shallow California blonde dude. It's kind of funny.
All right, we're getting far away here.
Yeah, sorry.
In other words, I would have had to have specific intent to hinder, delay, or obstruct, which I did not. I clearly stated I was a member of the press. Once again,
so what?
Again, yeah, so what?
It's completely absurd that I'm here. On page 12 of the LexisNexis of Wilson versus First Judicial Court, it says here, NRS 197.190, as required only under general intent to act, would raise grave doubts as to the statute's constitutionality. In particular, such an interpretation would criminalize a significant amount of constitutionally protected activity, like being a member of the press. For example, merely remonstrating with an officer in behalf of another, or criticizing, questioning an officer while he's performing his duty could constitute an unlawful act. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. This applies to both the case I'm in jail for now, unjustly and unprincipled, and this applies to my second obstruction case.
Yeah, it's crazy because, you know, he first of all, he expects you to be able to blanket the First Amendment.
Yeah.
It's like the blanket over everything. And if that isn't it, it's the direction of your interference. It's not directly at him. So maybe he was talking to the girl in the car. That was his argument one day in court. That bullshit. You can't blanket. You just can't do it. I mean, dig down in the Bill of Rights. That's why it exists.
Well, he makes many faulty generalizations.
Oh, it's frustrating because it's
in many different ways. Yes. You see why I was like,
right. He
so
just
wound up earlier.
Yeah. All he's doing is putting different icing on it this time. That's all.
4 paragraphs down on the left side column of page 12 of 17, it again states here, stating that determination whether someone held a belief had an intent is a true or false determination, not a subjective judgment, such as whether the conduct is annoying. United States versus Williams, as you know, is in the trifold. Therefore, we interpret NRS 197.190 as requiring that a person have the specific intent to hinder, delay, or obstruct a police officer in the discharge of their
all I can say about that is please enter the trifold into evidence.
Specific intent was only to film police. NRS 197.190 only applies to physical conduct and fighting words. I hope that the court of Nevada, I hope the District Court of Nevada hears these words. This case has already been appealed to the District Court, and they denied Wilson's appeal. It went to the Nevada State Supreme Court, and they overruled it. So that means this is my lawyer's argument right here. A First Amendment protected activity cannot be criminalized. You can't criminalize it because you don't like me or you find me annoying. I don't care. I will stand on my rights like it's home plate.
Yeah, but again, he's shifting to
Yeah.
that's the argument. The argument.
Yeah,
is
we've
not
already been there. We've already been there and done
whether
that.
you
And I
were
thought
calling the cop. Yeah. He's trying to make it about,
Zimmerman covered all this. She was, even though she kind of acted like she was having a rough morning, to say the least.
Wouldn't
but
you if you had
oh
to
yeah,
listen to the
absolutely. So yeah, I mean, she covered
bullshit.
that. I mean, she was specific about it with very few words. You know, it's not that you're filming, it's not about the annoying. You interfered. Period.
Yeah, if being annoying were a crime, he'd be doing a life sentence already.
Yeah, we wouldn't even know who he is. That's true.
Rights, and I will not back down for them. Now, NRS code 197.190 may reasonably interpret it as prohibiting speech that hinders, delays, or obstructs a public officer. You see, that is unconstitutional. You can't do it. Now, here's the big ones. Here's the ones I circled that are on page 13 of LexisNexis right here. Page 13, 2 paragraphs down.
He really wants you to know he's using the LexisNexis.
Constitutional concerns previously identified, the canon of constitutional avoidance obligates this court to further limit NRS code 197.190 application to physical conduct and unprotected fighting words. In other words, it's limited. I have to physically get in the way of the police or violently threaten them with words. Like, I'm going to beat the shit out of you. I'm going to fight you. Those are fighting words. You can't say things like that, which I didn't. It continues.
No, but he will after the fact.
Third paragraph down. A statute that made it a crime to willfully resist, delay, or obstruct a police officer requires the presence of some physical act or exertion against the officer, which I did not exhibit. As a matter of fact, in the second arrest, I was walking away and they started pushing me so fast I couldn't keep up and I had to stop and say, stop pushing me. They exhibited it. Now, the bottom paragraph, right-hand side, page 13 of 17 on LexisNexis, it says here, HN 18. Therefore, we, the Nevada State Supreme Court, interpret NRS 197.190 as applying only to physical conduct and fighting words. We note that obstruction does not require the use of force or violence, and that a person's actions blocking the path of an officer or inaction refusing to obey a lawful order may constitute a physical conduct that hinders, delays, or obstructs an officer, which I did not do. I did not do that. Finally, page 14 of last paragraph, HN 20. However, as constructed by this court, NRS 197.190 does not apply to protected speech. It applies only to physical conduct and fighting words. You locked me up in the face of Wilson just being passed February 8th, 2024. The Nevada State Supreme Court clearly outlined the exact standards for obstruction. I'm rightfully indignant. I've been locked up in this God-blessed dungeon for 3 months, and I tell you what, when I get out of here, I'm going to shake the bitters and the disgust and the
I think that was his old-timey ancestor channeling himself through there.
Yeah.
Hi, sir, I'm rightfully indignant. I've been in this God-blessed dungeon for a month.
What a turd.
Indignant, I say.
Walk out of here, and I'm going to turn around and I'm going to sue the shit out of you. You had no right to put me in jail. Wilson clearly establishes that I did not obstruct, delay, or hinder any public officer in any way, shape,
I
or
can't
form.
wait to see him get put in
I'm going
his
to put
place.
the entire thing up, all right? I'm going to put it on my website. You know what? I'll just have the editor put it in there. I sat up all night reading this entire case over and over and over. It's only 18 pages. It's pretty easy to read.
So you could convolute it.
There's more stuff I want here that I can keep reading. But I just wanted you guys to understand that this county, Clark County, you're going to have to pay me. You didn't have any right to lock me up.
You've had the opportunity to
there
watch
it is.
the trial and the video, both of you. What were your initial impressions?
So initially, I thought that the arrest should have never occurred. I think that he was not obstructing. And I think it will be interesting to see what Judge Levitt does with it on appeal. I think that he has created some interesting issues with his courtroom antics and post-conviction behavior, but his behavior on the day, at the time, the filming at the traffic stop, I don't think it rises to the level of obstruction.
What's an officer to do though when they've got somebody who is in their face and confrontational? And we can agree, Mr. DeCastro seemed to be somewhat confrontational, right? Go back and do your job, little doggy.
Sure.
Those kind of comments.
But first I want to address the comment in your face. Is 10 feet really in your face? The court record indicates that he was 10 feet away. Is that in your face?
It's a good question. It's a good question. How close is too close?
So first of all, I want to say that, my views are just mine. I do teach a lot of agencies here, and this issue is still being litigated, and one of my clients is involved in this case. But I will say this is that this is a tough situation. I mean, these police officers are tasked with a very tough job, and, officer safety is a legitimate safety concern, but we also don't want to, hyperbole, right? We don't want to think that everybody is out there to kill us. That's not a good mindset either. That's actually a very unhealthy mindset. How close is too much? I will say at the end of the day, what I teach my officers is that when it comes to obstruction is that you basically cannot effectively do your job. And I compare that with efficiently, right? A lot of these First Amendment auditors will do things where it causes you cannot efficiently do your job. You have to, talk a little louder. You have to, maybe, take your attention away and maybe address them for a little bit. That's not so efficient, but it's also maybe not illegal. I'm not saying we haven't really got to the brass tacks of what Jose's done in this case, but I'm just saying that's generally speaking, how close is too close? The officer, what I teach and my principles is that the officer cannot effectively do their job.
And you say First Amendment auditor. What is a First Amendment auditor? This is a newer term. I mean, I've done this job for 30 years.
Yeah.
This is the first time I've heard that.
Self-appointed
Maybe I need to be
title.
more in tune.
God damn it. Excuse me. Pardon my French. Can't believe I just hit that. Yeah. Well, no, it just goes, it just goes to show what I say all the time. A lot of people have no idea. Here's a guy that's in the legal system and he's clueless to what a First Amendment.
Well, it's just a made up appellation, no offense.
No, I
anybody
get that,
that's
but I
doing
always
that, the cop watching and legitimately. And I mean, but auditing is an actual process. Like there are
no, we get that.
high level programs you could go through to become an auditor. So it's just a made up. I just want to be clear that
putting
it is
putting a
made up,
fraudster with frauditor. Yeah, no, it's a made up thing. It's a moniker.
Bullshit term.
I get that, but I point that out all the time is there's people out there that need to know this. They need to understand this is going on. So they need to know what this is. And that's all I was hitting on that's why I emphasize it so much.
I got you. I'm not mad at you, my friend. I'm mad at the world.
I know. I knew. What did I tell you? I knew this video. That's why I said, earlier, what's a PBJ, without jam, and what's a BLT without bacon? We got dick bag tonight. I mean, you're going to be in full force. So yeah, I knew this video. I asked him earlier. I said, "You watch it yet?" And he goes, "No." And he goes, "Yeah, I'm getting ready to watch it." And I kept waiting to hear from him because I knew it was going to get him riled up.
Yeah, she's not. I mean, well, I don't know what her reputation is. I wouldn't want to say too much about her, but
Lisa.
Yeah.
Here, I got something for her. That's what she's got to say, right?
Sure. If you close your eyes, though, she could pass for one of the ladies on The View, I think.
Oh my God. Yeah. I've never watched it, but I know who they are, so I can imagine.
Well, just sort of in her, I didn't mean in the content of what she's saying. I'm saying her vocal
reminds
qualities.
You of specific. Got you. Yeah. No, I've picked up bits and pieces. I think it's Whoopi Goldberg and Barbara Walters, and I don't know. What's his name? daughter on there? The senator from Arizona, wasn't his daughter on that show too?
I think that was years ago.
Oh, okay. Oh, okay. Well, that's
But
kinda goes
I'm
to
just
show you.
saying she's got a little bit of I don't know, sort of Valley-ish sort of quality to her.
Does she? I don't know anything about her. All right.
The court record indicates that he was 10 feet away. Is that in your face?
It's a good question. It's a good question. How close is too close?
So first of all, I want to say that, you know, my views are just mine. I do teach a lot of agencies here, and this issue is still being litigated, and one of my clients is involved in this case. But I will say this is that this is a tough situation. I mean, these police officers are tasked with a very tough job, and, you know, officer safety is a legitimate safety concern, but we also don't want to, you know, hyperbole, right? We don't want to think that everybody is out there to kill us. That's not a good mindset either. That's actually a very unhealthy mindset. How close is too much? I will say at the end of the day, what I teach my officers is that when it comes to obstruction is that you basically cannot effectively do your job. And I compare that with efficiently, right? A lot of these First Amendment auditors will do things where it causes you cannot efficiently do your job. You have to, you know, talk a little louder. You have to, you know, maybe, you know, take your attention away and maybe address them for a little bit. That's not so efficient, but it's also maybe not illegal. I'm not saying we haven't really got to the brass tacks of what Jose's done in this case, but I'm just saying that's generally speaking, how close is too close? The officer, what I teach and my principles is that the officer cannot effectively do their job.
And you say First Amendment auditor. What is a First Amendment auditor? This is a newer term. I mean, I've done this job for 30 years.
Yeah.
This is the first time I've heard that. Maybe I need to be more in tune with social media.
So interestingly, in preparation for us to have this discussion, did a quick little, you know, search on Google to see, because there are lots of definitions for that phrase, because it is a relatively new phrase. And there are two prevalent internet definitions for what is being defined as a First Amendment auditor. One is exactly the behavior that Mr. DeCastro is engaging in, those that pull out their phones and record police activity. And another is
That's not all he does.
Pull out their phones and record activity in any public space. So it goes beyond that of a just police activity. But if I walk into a commercial business and I pull out my phone and start recording interactions between a patron and a customer, if the employee at that business calls the police on me, they have failed essentially that First Amendment audit, because the argument is that you should be able to record any interaction in any public space.
Bad.
And that puts down a completely.
Yeah, that's Hoyt. You know,
that's not a that's just also it's just not a very good
right
summary.
They've yet, of course, he hits on it here in a minute, that he starts adding the layers to it. There's more to it than just that. We know that. I mean, she put DeCastro out front and made it sound like, oh, that's all he does. He just goes and films police. No, that's what Ironton Auditor does.
Yeah.
Chille DeCastro goes out and interferes.
Different rabbit hole than from today's conversation, but I thought it was an interesting point of view, because it kind of ties into, I think, Mr. DeCastro's point of view and where he was at when he was recording the police interaction in the traffic stop.
So is the position of these folks that in public spaces there is no privacy?
Essentially, yes.
Generally.
That's the idea, and particularly with officers. Of course, officers have body cam now too.
So they're recording themselves. But I would also say, just before we go on to that, because I think that there are actually two types of First Amendment auditors. There's the first 1A auditor who want to be cool about it, you know. The first 1A auditor is those who just want to record. They just want to see police officers. They're actually hoping for a good outcome. They're hoping that the Constitution is complied with. And then there's the other First Amendment auditor who's like the Castro, who is really after three things: money, badges, and fame. They don't want to just watch cops succeed. They want to watch cops fail. And the way he acts.
Look at her. She didn't like that at all. She's not liking this.
Your job, little
dog.
And let's not forget, that's an admitted goal of Chille's.
Absolutely.
I mean, he hammered that home again with the thumbs up in court.
I like her look.
Yeah, but his stated goal is, you know, to dismantle law enforcement as we know it, you know, or you know, so.
Yeah, he's all about defund the police. He's all about. I mean, he's tried to pitch his stupid camera system. You know.
So again, I file that somewhere in the intent file.
I love the way she took her glasses off there. She really she didn't like the fact that he just reached over and smacked her is what he did.
He does not
little
want to
bit.
see cops succeed. Yeah, he's actually makes it very clear that he is very anti-police. And I just want to be clear that that's something to consider. But generally speaking, it's not illegal to record police officers in a public place doing a public act,
or to be anti-police.
or not to be anti-police. Absolutely, he absolutely has the right to be anti-police. Absolutely, and he has the right to say that during his presence.
But in this situation, there's no question he's antagonistic.
Correct.
Right? He doesn't want to back down. He's at another arrest where he was also antagonistic.
Right.
Told an officer, "Shut your mouth. I'm an important guy.
Right.
I'm on YouTube, and you're going to look like a fool. Just shut your mouth and mind your own business. You know what's good for you."
Right.
I mean, he is clearly antagonistic.
And he's good. He's very good at it, by the way. If you watch his videos, he's highly effective. He's sharp when it comes to this antagonism.
Being
Yeah.
antagonistic doesn't always rise to the level of being a crime. I mean, in this case, I realize that argument sounds ridiculous because he was arrested and now sentenced for obstruction. But had he been 20 feet back, would we be having this conversation?
I think the key, though, is it's not that he's committing a crime by being antagonistic. I think it's that you have an officer who is allowed to consider his antagonism. He's allowed to consider that this person clearly does not either see me as legitimate authority or whatever, and he's allowed to consider that part of his officer safety issue.
Agreed.
Understood, but
and
in
that's
this
another thing
instance-
that Chille has said. I have absolutely no regard for officer safety. You know, he
And
mocks the very idea of it.
And let's put a little civility in here. So the officer doesn't have any personal feelings or rights either. And I'm not saying he can use the law for that, but what I'm to her argument. I mean, to what she said.
Unfortunately, I get what you're saying because
I'm not saying,
you know,
I'm not twisting it with the law. I'm not. That's not what I'm saying.
No,
when she said, how far is far enough away? Well, 20 feet might be far enough away, and you can stand there and you can say everything you want to say. But just as soon as you interfere, as soon as you take the officer's attention away from what he's doing, that's interference. Now, who determines whether or not his attention's he does. It's up to him to make that determination. So, I mean, granted, you got to be skilled to be a cop anymore, no doubt about it. But that was my point, is that he has to have there has to be something there that's subjective to him.
I see what you're saying. So consideration, you're talking about hit. I see what you're saying.
Right. I mean, at some point, the decision has to be made by the officer on the scene. All right, now he's taking my attention away from my stop.
Yeah,
but it's the cop that determines that. Yeah, he doesn't get a phone call and say, okay, you know, I mean, he has to make that decision. That's what I'm talking about. You have to take into consideration that he has rights, not rights, and I'm not twisting with the law, and he has to deal with emotion too. I mean, this is all deals with emotion. This is all about emotion. so it factors in there, in my opinion. So whether he's 20 feet, 30 feet, 10 feet, 9 feet, whatever, he has freedom of speech. He has all that stuff. But just as soon as he obstructs, but who determines that? And that's where the courts would come in. That's where you would go to court and say, okay, judge, you have to decide this. Was it fair for him? You know, is this adequate? Is this not adequate? And that's why all this is going in the right direction. The only problem we have, it's Chille. So we have to listen to all this crap leading up to it. We all know that when July 10th comes around and they have this hearing, we don't know which way it's going to go, but we know the laundry is going to get done, at least to that point. As much as that court can do the laundry. I've been watching this Levitt. I like her. She dealt with Blandino, for God's sakes, you know, so she's not a discount judge at all. All right. That's all.
Yeah.
Sorry.
No,
I got my rant in.
Part of this is whether or not you're stopping an officer from doing his job, right? That's part of the,
I think so,
part of the fundamental definition I would think of obstructing. And in this instance, before DeCastro is ordered to go to the police car, he lets the motorist go.
Right.
His job is done at that point. And the resisting's about the walking to the police car, which DeCastro's doing. He's disgruntled about it,
Yeah.
but he is doing it. I'm a little, it seems like we're having it both ways to some extent, if that makes sense.
The only thing I will say about this, and I love your point of view on this, is that at the end of the day, if we believe that a crime has already occurred, that he's already obstructed, which we can debate about that, then he's allowed to now have discretion. So you know what? I have a bigger fish. You're my small fish. You're just doing a very minor traffic violation.
That's right. How many times have you seen a video where a cop's on a traffic stop and all of a sudden he gets a call that there's, a robbery or a homicide or something? I mean, this is your lucky day. You're not getting the ticket. Bye.
In fact, it was like registration issue. You're out of here. Now I'm going to deal with him.
Sure. But what would the normal everyday obstructing, would it always result in an arrest?
No.
Well, it's discretionary, right? So many years ago, I had a case that was kind of similar to this, where it was a traffic stop and it was a sovereign citizen case, which again, another rabbit hole, but officer asked my client for a driver's license. He didn't have it because he had a constitutional driver's license, and it led to an obstruction and a resisting charge because my client couldn't produce a driver's license. And so ultimately, as my client was shuffling through these papers trying to find his constitutional driver's license, the officer felt like he wasn't complying with the command fast enough and ultimately pulled my client out of the car, which led to the obstructing and the resisting charge.
I feel like there's
so
parts
in
missing out of that story.
Yeah, I'm sure there's a lot more to it.
Detail.
I wish you'd mention a name so we could look it up. I bet there's a video somewhere.
When have you ever seen like a cooperative guy with a constitutional driver's license?
I like that one the other day where they paid all that money off the internet to get the printed license tag and the little cardboard tape up thing on the back window, and the guy's on the phone with his wife or girlfriend, whoever it is, and she's giving him directions on how to handle the car stop. And he's holding the phone up and she's talking him through how to handle his first soft set stop.
Oh yeah.
Did you see that video? Yeah.
No, I've seen ones like it though. Where the guru or whatever is on the phone and giving instructions.
Exactly.
It's just like,
exactly. And he thought things were going to go his way.
I don't think there's much of a difference between my client attempting to produce his constitutional driver's license and what Mr. DeCastro was doing in this case. He was standing 10 feet away, yelling obscenities at an officer. By the time he got to the point where he was walking to the car, we have compliance.
You have a biased and unprincipled judge, Ann Zimmerman, who put me in jail because she loves cops. She even said to me, "You hate cops. Well, we'll see about that." And then she put me in jail. Then when I went to,
is he gonna? I mean, is this something he would? Is he gonna argue this? Did he put this? Did he put that in one of the appeals? He kind of was borderline insulting into to her in one of them, if I remember correctly, man. I don't know. This vitriol towards her. Let's see what it can't possibly achieve anything for him.
No. As much as we'd like to think that that a judge is going to be perfectly, be able to blank all that out, and we're dealing with emotions. I mean, not to say that she would alter, but it has to have a bearing where there comes a time. This is what I like about Patrick. He's so clear. He clarifies things so well. And not all judges and attorneys do. And but
yeah, we're very fortunate to.
Very fortunate. It's he's very clear. Very anyway, and he finishes it.
In my appeal bond hearing, she said, "Have you seen his YouTube videos? Have you seen what he's saying?" Meaning she went outside the scope of the case. That's not right. It violates judicial canon number 1 of the Nevada state constitution. She cannot do that. She's violated my rights. In Clark County, you're going to have to pay.
She can't watch YouTube, boys and girls.
Yeah, she can't look at anything in the public and take it into consideration.
That's right.
She has to wear blinders.
Oh, that's a good way to put it. Blinders.
Absurd. This is absurd beyond the pale. So, all right, let me do this. Let me take a breath here.
Absurd beyond the pale before I have a heart attack.
Let me talk to my people. All right.
Oh boy.
There's that laugh.
This case,
All right.
when you read Wilson versus First Judicial District Court, and it has
Can we,
to go there, it
Can
is
we maybe
so-
switch that to a whip or something?
Do what?
Can we maybe switch the gun with like a whip?
I guess. But
Little more comical, a little less jarring.
yeah, well, I'm not comical. I'm jarring. So
Well-
and I owe everybody. I swore a while ago, and I have a new swear tool.
Nice.
Well, it makes it easier for me to go back and do the edits.
Nice.
Okay.
so unbelievable that I've been in jail for this long. This case was just decided February 8th, 2024, and that biased, unprincipled judge did this. Well, sorry, Nevada taxpayers, but I'm going to sue. Okay, so there's only 2 more paragraphs I want to read here on page 16 and 17, 16 of 17 and 17 of 17. And this is for the court coming up for my appeal on July 10th. It says here, the district court did not have the benefit of our interpretation of the Nevada State Supreme Court as being limited to physical conduct and fighting words, and it therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or uttered fighting words so as to support her conviction.
That's Wilson.
Yeah,
So,
Wilson.
That's
not
Wilson.
you,
That's
stupid.
not DeCastro. Yeah, if you're going to compare the two, that's the whole thing about case law, Chille. If this is case law,
He can't read case law to save his ass.
yeah.
He's proved it time and time again.
Of violating 197.190. And then on the last page of page 17 or 17, the very last paragraph, HN 29, for the reasons discussed above, we conclude that NRS 197.190 only applies to physical conduct and fighting words that are specifically intended to hinder, delay, or obstruct a public officer, and thus the statute is not unconstitutionally overbroad or vague, either on its face or applied to Wilson. However, in light of our interpretation, Wilson's as-applied constitutional challenges are more properly viewed as challenges to the sufficiency of the evidence. Because the district court did not consider whether there was sufficient evidence to support Wilson's conviction, we grant the petition and direct the clerk of the court to issue a writ of certiorari upholding the constitutionality of 197.190 and instruct the district court to reconsider Wilson's direct appeal for the sole purpose of addressing whether, under the court's interpretation of the statute, sufficient evidence supported Wilson's conviction. Overturned. Just like that. Just like that.
It's like
How
that.
in the world is
Oh,
really
I
think,
can't.
yeah,
when Wilson
he really,
exists? It's so
Yeah, I can't wait for July 10th.
dude, he really thinks this is the magic bullet.
Yep. He's not talking about the board game anymore, is he?
No, but he does mention he's something else.
And this video, I didn't watch it all the way to the end.
It might be this one. It might be the other one.
I'm not going to carry this burden with me. I'm not going to carry this resentment with me.
I'm just
going
gonna
to
sue.
And I'm going to sue Clark
Right.
County. And I'm going to sue that judge. And I'm going to sue that bailiff. And I'm going to get those cops' attention for arresting me. You guys lose your qualified immunity. All of you do. And the judge loses her qualified immunity as well for illegally searching me before the trial began.
Again,
Let's see what happens when we go.
it's not losing qualified immunity.
That's right. They don't carry it around and have it taken away from them.
Mr. Constitutional Law Scholar.
Yep. And it's her courtroom. So your Fourth Amendment rights, I don't think would stand up. It's her job to protect the courtroom.
Yeah.
And you've
Pissing on the
already,
rope.
and you have proven that you are willing to be a sneaky little prick and try to pull something like that off, right?
Go down the
Yeah.
legal process because I'm going to hire the best civil rights attorney in the country. I'm not going to go pro se. No. I'm going to hire the best civil rights attorney in the country to sue you bad people. That's the best way to put it.
Bad
All right,
people.
so I'm
Bad
fired up this morning
people.
because I read this all night long. I read it again.
Bad
What?
people, Mommy.
It's going
Bad
to be
people
funny.
are coming.
All the people that are hitting the GoFundMe right now, when July 10th comes around on the 11th, they're going to be questioning themselves the next morning.
What an 8-year-old. I mean, yeah, I mean,
Yeah, it's like Hoyt, real adult, right?
yeah. That would be, can you imagine Hannibal Lecter suing the court because they made him wear a muzzle, even though he's known for eating people? Don't know why that popped into my head.
I don't either.
Obviously, I'm not comparing.
I just got an image of somebody walking by.
But I mean, that's how
walking by,
stupid
he
that
reaches
is. It's
out
like,
and takes a bite out of their arm.
right. I mean, if somebody's known for something, the judges obviously,
That's
yeah,
right.
like you said, it's her court. She wasn't. Jeez, what a moron.
That's right. And your
Oh,
it is your reputation.
I read it again. So there it is. Now you know.
You read it
Put it
so
on your
much, you
calendar.
molded it the way
We
you
are
wanted
4
it.
weeks and 1 day away from the appeal. I don't know how Michelle Levitt can read Wilson for my appeal on July 10th and not overturn the conviction of obstruction.
She's already
I clearly
reading.
went there to film the police, clearly invoked my First Amendment right. And even still, I wasn't there to hinder, delay, or obstruct. I was there to film the cops' interaction. You cannot convict me of obstruction.
yeah. And what was your intent, Chille? And
Right.
what was your intent with all of that?
Yeah, and even if he was there just to film the cops, that's not what he did.
Right.
He did more than film. I mean, he always does.
Yeah,
I honestly
jumped
think
into
the second
situation.
I think the second case, the one that took place on the corner with the motorcycle cops, I actually think that one contained way, even though they weren't investigating at the time.
Oh yeah. And they had more cause. I mean, they looked up his warrant. I mean, that cop was pretty chill. The cop in charge, because it could have gone a lot worse for him there. I think because he flagrantly disobeyed the traffic sign right in front of them, and then he gets out of his car, lifting his shirt up, just like acting like a crazy person. That's what you don't get, Chille. You look like a crazy person. If you were coming up on me on the sidewalk, I would, first of all, I'd see you a block away. I clock things like that when I'm out in public because people are nuts, dude. And when you come across nutty, people are gonna react differently than to you than if you're just minding your own business. Can you imagine if he had just kept his mouth? Well, like you said, emotion, that is absolutely the thread that just runs through all of this. He could have just taken a plea and been done with all this. Even if he was trying to make a point, he should have done it quietly, respectfully, listen to the likes of Patrick, and he might have been able to actually affect some sort of change, statute wise. And no, instead he's got to just shoot his mouth off, be a hard on all the time, and that's why he's where he is.
Nutella.
Sorry, everybody. I'm agitated as hell.
Frustrated, but I'm in this frickin' dungeon. And so what you guys don't understand is that the guy who's in the front of this place, the guard of this room, of this dorm, of this bunk, of this pod, whatever you want to call it, that person dictates whether or not you have a decent day or whether your day totally sucks. Some of these guards come in here, And I'll be honest with you, some of these guys are pretty chill people. They're pretty laid back. They don't say much. There's a system here. It's a very, very simple system. Chow time is at this time. Meds is at this time. Commissaries at this time. Commissaries tonight. So I'll get your eye care gifts packages for you guys who sent me up tonight. Really appreciate it if you did. Thank you. I mean, it's just some of these guards come in here, they don't say much. You follow the system. Everybody gets up for chow at a certain time. You know, there's very specific time slots.
They're doing their job.
Oh yeah, we get it, Chille. We understand the concept of prison. It's taken them this long.
And it's just, I just don't understand it. You know, I don't understand that why some people are so calm and so chill, and then other of these guys
Yeah.
they get here to the time they leave.
That's coming from his mouth.
I just don't get it. Yeah, Blackheart Knight is yes. Yeah, Blackheart Knight. Yes, excellent point. Chille just won't listen to he refuses to listen to smart people because he has to be Mr. Smarty Pants. They even mentioned that in the little panel there. You know, the guy says he's trying to be Mr. Big Important Man. You know, and that's after just a cursory introduction to Chille. You know, go back and watch his videos
For 2 years.
or listen to, you know, Tina has firsthand experience with that when they were on camera together. You know, he was basically trying to direct her what to say, and you know, and Colin tells stories about Chille. No matter what you say to him, if he's got his mind set on it or whatever, if, you know, he's the ultimate authority. So, you know, good luck. Good luck getting through to him.
So why very patient? You know, I just don't get it. And there's other things, but I don't want to say anything, you know, other than that. And I'll just leave it at that because I can't really say anything right now. I've got to make sure that I stay safe in here, and I haven't been abused. I haven't been mistreated other than put in the hole for live streaming. So, but you know, the dichotomy between my day, the up or down of my day, the positive or negative of my day, is all dependent on which guard walks in the door. And that's the way it is. Whether you like it or not, when there's someone screaming at you, you can't reply. You can't have a bad day in here. If I reply to the guard, I go to the hole. If the guard's yelling at me and it doesn't make any sense, you know what I say? You're right, sir. I was wrong. I should have known better. I mean, it's just you can't in any way have a bad day in here. You got to be careful with the other people you're around. You have a negative interaction with one of these guys in here, any one of the 70 guys in this pod with me, and they punch you, you're going to the hole. You lose your good time. So I'm in a system of chutes and ladders and pitfalls and pulleys and hooks and levers, and if I step the wrong way,
What are you talking about?
my life, like, it's not a joke. This is very, very serious, and they put me in this place when Wilson exists. So to Team TLZ and to the faithful, God bless you. Thank you. I appreciate you. I love you. I will not stop until we change this system. I guarantee it. I have invented a new device.
Here it is.
In place of torture cuffs, to get rid of torture cuffs altogether. I've already sent it off to my lawyer to begin the patent process. So I'll let you go. Thanks for listening to my daily journalistic.
Another point to make when he was talking about being out of control and emotions and so on and so forth. Have we ever seen him use the trifold as he teaches it to be used?
No.
No.
It's I mean, I did the video on you know,
right,
on how confusing his instructions are, you know, and how come he doesn't, and how come there isn't one successful. Yeah, I mean, the trifold is a bundle of problems. But
all right.
I mean, he's patented. When he was I was thinking of the volleyball Wilson in Castaway when he was talking just now. But Wilson exists. I should be a free man.
Oh goodness.
What a momo.
What a momo.
I desperately need
Yeah,
some
no,
sanity.
that's
So
what I'm pulling
let's
up.
play Pat's video because
That's what I've got. That's what I've got in the window, and I'm going to walk away from the microphone for about 2.5, 3 minutes while this is playing. So I'll pause when I get back. So hold your thought.
Okay.
So I found a really old sovereign citizen case, 2012. This soft sit got busted in Missouri for drunk driving and revoked license. They gave him both sentences concurrent, so he got 270 days in jail. Then he filed a writ of habeas corpus in the Court of Appeals, in the Federal Court of Appeals. Case was blown out. Let's just take a look. It's kind of interesting. So here he is on this case in 2012. Federal petition right here, 28 USC 2254. And the first problem he's got is you can't petition the feds until you've finished resolving what are called administrative rights within the state. Federal courts are courts of limited jurisdiction. You're driving while intoxicated, 90 days, $500 fine. Driving while revoked. He's claiming that his license wasn't revoked. The highest state court does not have jurisdiction of the written law in Missouri of the United States of America or to the American people who live there, work there, or move there. If you did not exhaust your state remedies, see, they want to know why, because otherwise they don't have jurisdiction, the feds. The written law jurisdiction of the state courts are the same as the state of Missouri federal corporations. He seems to think that the state of Missouri is a federal corporation, so therefore he's in the right place. The courts of the United States of this state have same written law jurisdiction of this state. Sounds a little circular to me, but okay, we'll continue on here. Don't really get that too much. This habeas corpus to the territorial component of districts and divisions by counties, the district court. Doesn't sound like you're answering the question here. Because the legal age in Missouri of the United States of America is 21 years of age, the territorial state age is 18, and there it can be revoked without the court. Imagine just trying to understand this stuff. It's like gibberish. To restrict in any fashion the movement of an individual American without consent and the free exercise of his natural rights is a serious breach of freedoms secured by the four organic laws of America. The organic laws. The Declaration of Independence creates no government. The Articles of Confederation of November 1577 create a Congress of the free and independent states and a federal government. The Northwest Ordinance of July 13, 1778 create a temporary government of taxation or territory. The Constitution of September 17, 1787 creates a more permanent administration of the written law of territory. All state courts only hear written law jurisdiction in national parks. Whatever. Of course, he's not talking about the Administrative Procedures Act, the APA, which goes into great detail about how the United States is formed in terms of its current statutory makeup. I, an individual American man, have never consented to be governor general in America. I am the owner of my life, body, and soul. No, you don't own your soul, by the way. I think your soul is owned by God because he's the one that decides what goes with it. So you don't own it. That's why you can't make a deal with the devil. Devil doesn't own your soul. He may make you think he does, but he doesn't. How can any written law person be a citizen of the United States and the stat wherein they reside unless both are the same? Venues are and politically or administratively or corporately the same. That's more of a rhetorical question, so they're not going to answer that. You have burden of proof here, not just throwing out these questions. May sound philosophical, but they don't mean shit. As including a
Yeah.
born alive infant be anything but fraud.
Chille.
No parent would place into involuntary servitude or slavery any man or woman if informed, nor would any registered nurse or doctor. Okay, well, I'm convinced. All right.
I own my signature and not the name attached to the state of the document. This was the sheriff responding to it with just 3 pages, very persuasive. They just said he was found guilty of driving while intoxicated and driving while revoked. Notice that they spelled it right. Never appealed the conviction. He has, this court doesn't have jurisdiction yet because Missouri, the state courts haven't finally ruled on anything, and he may be out of time to do that anyway. It says individual man, he never consented to jurisdiction of the Missouri courts. That's a nice little slap. He filed a response, which he thought probably sounded really intelligent. He says he's coming in through special appearance again. They love using that. Driving, which is not defined by the legislature. Yeah, I think it is defined. Our irrelevant automobile is not being used in a commercial activity. Yeah, there we go. Sovereign city. He doesn't bring up the UCC though. Petitioner was not a federal employee nor in commerce at the time of his alleged commercial crimes. Close, of driving a motor vehicle regulated by federal employees of the executive departments of the state or the DMV. Actually, the state can also monitor this, not just federal. And then he has the organic laws of America, and he's not entered any commercial agreement with the state. Then he goes on to give his dissertation of the 56 states of the United States. I think that was a typo. Jurisdiction must be proved by the prosecuting attorney. They love that one. What jurisdiction you have over me? Well, actually, the fact that you're here, that you broke a law that's under the state's police powers, the fact that the state can enforce its own police powers, the fact that the state has created courts to deal with these things, and all of that. Yeah, I think they've got jurisdiction over you. The founding fathers did away with the tyrannical government in America, all that royalty stuff. Very well said, very articulate. There'd be no noble class. Well, I don't know about that. I think the founding fathers are a pretty noble class. That was the nobility if you ever saw it. Federal judges employed to the Superior Court of the state of Missouri. Don't really see that too often. Most federal judges are employed by federal courts. And against willful misrepresentation for any licensed U.S. federal law enforcement officer employed by a department of this state to attempt to appear in any federal court. I see federal law enforcement officers in court, federal court all the time. Then George Washington took his oath. Well, I'm glad you mentioned that. Really great history. They didn't want this new monster in their own state, so they set aside a 10-mile square of land forevermore to serve as a seat of government. I guess he's referring to D.C. The power to adjudicate individual American private rights must be vested in Article 3 court. And then he gives his little speech. So there you have it from 2012. This is the oldest sovereign citizen case I can find. Not much has changed. Game is the same. Conviction.
All right. Did he do a Chille video as well? Responding to that, well, the video we just watched, or I thought he had another video up as well.
He dropped one after this one. But just to change things up here just a little bit.
Did you switch mics or something?
No, I wasn't talking into it.
Oh, it sounded like you were.
I pushed it out of the way for a moment. I had the hiccups. Okay, so we're just going to change this up just a tad bit here.
Let me know, guys. Let me know what you think. I'm right here. I see some detractors in the chat room. Let's just go off script here for a second. If you got something bad to say, I'll bring you up. Put a 1 in the room. If you got something bad to say about Chille, or you got an opinion, I would like to hear what your opinion is, and I'll give you the floor. I'll let you speak your piece. You let me know. Let me know if you guys want to do a, kind of a back and forth. Truth fears no scrutiny, guys. If you think Chille belongs in jail, which I vehemently disagree with, because I have not seen any victim produced, any harm done, or damage.
The eyeball.
That Chille is rightly sitting in a jail in Nevada. Let's hear your thoughts. Stanley is here. What's up, Stanley? How you doing?
Yeah, I'm fine.
Good. And what you got?
I got that. Chille doesn't belong in jail. That's something I think, because he's always shouting Maybe it's wrong, but it's right in America. That's what it looks like in America.
It does look like that. Now, where are you from?
I'm from Holland, Amsterdam.
And are you still there? Or are you in America?
No, I'm in Holland at the moment.
What state?
Amsterdam.
Oh, you're in Amsterdam now.
Yeah.
Oh, okay. So what's the
capital city of Holland?
Hey, thank you, man. Take care.
Okay. Bye-bye.
All right. Adding SK. What's up, SK? What's on your mind?
No, you know who I am. This is Scott Keller.
How's it going, man?
You know, every time I listen to you, I don't know where to laugh or call a paddy wagon. You got this theory that any law that has no victim should be abolished and no officer of the law should enforce it because the almighty Brian Young of Oklahoma, redneck Oklahoma, said so.
That's quite a few ad hominems. Is that where we're going with this conversation?
Well, that's what you think. He broke the damn law. His only mistake was he didn't have a jury trial.
Is it redneck Oklahoma? Is that how you view it?
No, inbred Oklahoma.
Oh, inbred. Okay, is that your opinion?
That's my opinion.
And what do you base that opinion on?
I'm a truck driver. I drive through that area. I've met many of the inbred idiots in that area.
Oh, you know for a fact that they're biologically inbred.
They act it.
Okay.
And they look it.
Okay, so you believe Chille should be in jail then?
He's not lying.
He broke a law that's on the books.
What law did he break?
The laws he was charged with.
I am an Oklahoma redneck inbred, and Chille broke a law. You were. I hate. You were.
Oh my.
Oh, good one, Derp.
Yeah, I know
Oh,
Derp just went through something serious. And I want to send some well wishes out to him. I know he's put a video up recently that kind of detailed the harrowing circumstances of what he went through, which my apologies, Derp, if you're out there. I have not been able to bring myself to watch the whole thing yet. And that's absolutely no offense meant to you on that, man. I just I've had some death in my life recently, and it's just you know what I'm saying. I'm just
I'm sure apology is accepted.
But I will I do please everybody else please go try and support Derp and send him some words of encouragement. I do owe him an email at least, so I should put what I just said in email form and send it to him. But I'm glad that you're well, buddy, or at least on the mend. Feel for you, and we all got your back because we love what you do.
This is true. We love what he does. You really want to do this, or you want to save it?
What, the other Chille call?
Yeah.
Yeah, we can do it. It's up to you, man. It's
No,
your
I
show.
don't. No, it don't bother me. It doesn't bother me.
I saved. Why keep a light over this bushel?
It's just we got into some lighter stuff, and it felt like a big relief to watch something else.
Yeah, reverse what I just said, by the way.
What?
Yeah, what? You have a gift to share with the world. Share it.
Share it. That's not Chille. Okay, put this mic back on here. Whoa. All righty, so we're gonna watch his last. Oh yeah, it's under live stream. Back it up a little bit because I was watching it. And
As we call it, the state-run media. However, I think this goes out to all media representatives because this
Is that it? That's not at the beginning, is it?
it or not, or you like journalistic update, the respondent answering brief, and this message goes out to the media. In
Very
Louis
close.
Brandeis' day, when he was confirmed for the Supreme Court in 1916, they would have called the media today the kept media because they were kept by the railroad barons, by William Randolph Hearst, by John D. Rockefeller. And so today what we call the media is we call it the state-run media. However, I think this goes out to all media representatives because this concerns you. Whether you like it or not, or you like me or not, I am a journalist. And what I do specifically is I film police when they pull someone over or in their official capacity, any place, anywhere they are. So this must be addressed. And so this goes out to the mainstream media, to the regular media, to the state-run media, to the traditional media, whatever you want to call yourself, because I am the new media and I will continue to film police to be.
Challenge
So this is an answer to my appellate, to my appeal brief, and it's a respondent's brief from Stephen B. Wilson and Alexander Chin. It starts off on page 1 where it gives the statement of the case. And you can read down page 1, March 15th at 4:30 p.m. It was 2:30 p.m. And then it goes down to the statement of facts at the trial on March 15th, Las Vegas Metro Police Officer Brandon Bork at a traffic stop near 4155 Grand Canyon. He was in a car. He pulled over a woman. Next page, page 3, she seemed a little bit confused. Bork asked the driver for identifying information. And then it says, appellant then approached the driver and began speaking to her from roughly 5 to 10 feet away. That's the first lie right there. I have filmed hundreds of police in over 30 states in America, and I have never gone within 5
Yeah,
feet.
you're known worldwide.
One
You're a
time, I walked up
constitutional
to
law
a
scholar.
Stop, and I was actually right by the passenger side door. And when the cop said to me, "You're too close," I looked at the driver's side door and passenger door, and I said, "I'm so sorry, officer." And I stepped away because I was too close. That's the only time in the history of me filming.
Dude, I don't recall.
I'd
Yeah.
love to find that video.
Yeah, I don't recall ever seeing a clip where he said, "I'm sorry, officer, I'm standing a little too close." He took 2 steps forward.
Pardon me, sir. I am so terribly sorry.
God,
Sounds like-
did
sounds
they
like Chille.
not remember that all of this is on video, for God's sake?
Well, I mean, except in this case, because I've never seen that ever.
Yeah. I rest my case.
Cops, because I've been within 5 feet. I'm always at least 10 feet away. It's a lie. So if they'll lie about me, state-run media, traditional media, then they'll lie about you. And you're next. At that point, Officer Bork exited vehicles and ordered the appellant to back away. Now we go down to the second paragraph, and it says, instead of backing away, appellant simply continued to argue with Officer Bork. That's not true. I informed him that I was a constitutional law scholar and a member of the press.
Does he think that if he tells the lie long enough and tells it enough time that everybody will start to believe him just because it works on
law scholar. I'm a constitutional law scholar.
it works on himself?
Yeah.
Moron.
So yeah, it's definitely
interaction.
Yeah, it is. It just drives me crazy that he continues to push all this. And it's like, okay, well, I guess you've said it enough times now. I believe you, Chille. Forget what the video says or shows.
Explained he was trying to get the appellant to back up approximately 21 feet for safety concerns for everybody involved. He explained that backing someone up to 21 feet so he can continue to do his job without interference is commonly taught in training, but it's not a code, statute, law, or ordinance. It's simply not. So they're saying things in here that are fundamentally untrue. The next paragraph down says Officer Bork was concerned for his own safety as well as the driver's safety. He did not know anything about the appellant or what his motivations were, or if the appellant was armed. No, but what he did observe is that I was filming the interaction, that I informed him I'm a member of the press. And in the history of people filming the police, they've never been filming the police and pulled out a weapon and shot the cops. So let's get
yeah, okay.
And then
So
the next paragraph
this is great. It hasn't happened yet. Therefore,
Right.
it will never happen. They don't have to worry about it at all. You might as well get rid of your guns.
I can't wait for July the 11th.
down it says Bork.
because I mean, after this is all nonsense, it's all going to get shut down. There's no argument here.
It says, during Officer Bork's interaction with the appellant informed Officer Bork that he was a member of the press. As I have two cameras, one actively rolling. On the next page, page 4, it says, and here's where the lies really begin to pepper up. Third line down, first paragraph. Appellant refused to go in front of the patrol car and to continue to film. Officer Bork attempted to escort the appellant over to the patrol car, but the appellant swatted his hand away. Officer Bork then grabbed the appellant by the shirt and spun him around so that he was in front of the patrol car. Lie after lie after lie. Bork reached his hand out to me. I put my hand up in front of my cheek. My hand was maybe 6 inches away from my own face because you have to protect yourself at all times. And when a hand is coming in at you, it's a natural reaction to put your hand up in the air. Bork's testimony will even say that he did not believe I was trying to fight him
30 years of MMA taught him that.
or attack him.
Yeah.
I simply put my hand up because there was a
You're
hand coming at my
trained.
face. It's a lie. I didn't swat away the officer's hand. That's not true. That's false.
God.
If they'll lie about me, traditional media, then they'll lie about your reporter next. And then it also continues to lie to say, once in front of the
About
patrol car,
splitting
I
hairs.
walked 30 feet to go in front of the patrol car. Appellant also testified at the trial and explained that he films police officers for a living as a member of the press. Appellant said he was only willing to take a couple steps back in order to move away from the stop. Appellant stated that his understanding of obstruction, it was a physical act that you have to get in the way. That's exactly correct, and that's clearly defined in Wilson versus First Judicial District Court, where they define obstruction as willful intent or the intent to hinder, delay, or obstruct.
Holy crap. This is 30 minutes long. I didn't even realize because I was listening to him on like 1.5 speed because it was so, I forgot it was quite this long. That's another reason I quit.
I got you. I got the message.
This is long.
From the police. Now, with the fourth paragraph down, appellant stated that when ordered to back up, he backed up a foot or two and was at least 10 feet away. When the officer explained that the driver deserved privacy, appellant instructed Bork that he was to go get in his car, little doggy, and write his ticket. So I told him to go do his job. That in no way obstructs him. He could have went and done his job. Last paragraph, and this is where the big argument begins. It says, now this is the big one, and for traditional media, I want you to really keep up with me here. Appellant argues that his conviction must be reversed based on his First Amendment right to record Bork's traffic stop. When appellant had a First Amendment right to record the traffic stop, appellant did not have the unfettered right to record the interaction in the time, place, and manner that he thought he was entitled to film. Okay, so what time is it? 2:30 in the afternoon. What manner is it? I'm holding a phone up announcing that I'm a member of the press. What place are we in? We're in a public place, in a public parking lot that's very busy, a lot of people around. I'm wearing a bright neon blue sweatshirt. Time, place, and manner is clearly established that if you're a psychopath who wants to go off and kill cops, you're not going to do it in the middle of a busy parking lot at 2:30 in the afternoon wearing a bright blue.
What?
Says who? Yeah,
Yes.
that's the big one. That's the big
Yeah, what a great argument that is.
generalization.
It's absolutely preposterous. Time, place, and manner works on my side. Then as we go on to the next page, page 5, second paragraph down. This is really funny. I'm not sure what Wolfson or Chen are thinking by publishing these things or putting these into the respondent, but let me just read it here. Fields versus City of Philadelphia, second paragraph down. It goes beyond protection of the press and self-explanation of individuals to prohibit government from limiting the stock information from which members of the public may draw. That works in my favor. You don't have the right to limit my information by telling me to move 25 feet back when I was plenty away. Then it goes on to mention First National Bank versus Bellotti, and it says, it is well recognized that recording police activity falls squarely within the First Amendment right to access information. It works in my favor again. And then he quotes Brasenberg versus Hayes. The right to record applies equally to the press as well as public. So now time, place, and manner is middle of the day, announce I'm the press, wearing a bright blue jumper, hoodie, and the cop says he's scared. And so then it goes on here. Now I'm going to go down two more lines here. I find this absolutely preposterous. And then right here it's going to say, in Zemel versus Rusk, the right to speak and publish does not carry with it unrestrained right to gather information. Otherwise, valid laws serving substantial public interest may be enforced against the press as against others, despite the possible burden that may be imposed. It quotes Brasenberg again. Reasonable restrictions on the right to film may be imposed when the circumstances justify them. So what circumstances are we talking about? What circumstances are we talking about here? We're talking
You
about what?
acting like a
We're talking about
crazy
middle of the
person.
afternoon, 2:30 in the afternoon. I've announced I'm a member of the press, and he gets insulted because I called him a little doggy. The truth is that he got insulted and he lost the school. But I want to go point by point here because, and then it says the United States Supreme Court recognized that traffic stops are inherently dangerous for cops. Well, it wasn't so dangerous. We're in the middle of the parking lot in the middle of the day. And then this is the funniest part of this response. It quotes Turner versus Driver.
I missed that the
The
first
First
time
Amendment right
around.
to record police does exist.
Say what?
I missed that little nugget the first time around.
What
You
was
just brought it up again, like that. Oh, because it's in the middle of the day, the cops in absolutely no danger. I think you pretty much consider yourself in danger from the second you put on your uniform in the morning till the time you go home at night, and possibly sometimes even after that.
I can think of the last 3 state troopers right off the top of my head. It was one of them was 10 o'clock in the morning, one and the other ones were in the afternoon.
Yeah, dude, what the fuck does the time? I mean, he's like trying to paint it like the only option for crime is
Sorry.
You know, in the middle of the night in a dark alley, you know. I mean, give me a break, man. Lunatic logic.
I had some interference there. I'm sorry.
And act and protect the integrity of confidentiality of the investigation.
Yeah.
You're right. He could have asked her to step out of her car and come back to his car because I was more than 10 feet away and I'd already backed up a couple of feet. So then it goes to page 7 and it quotes Glick versus Cunniff, which is time, place, and manner. Smith versus City of Cummings, which is time, place, and manner. And then it says appellant was charged with and convicted with violating NRS code 197.190, and it quotes Stubbs in here. Stubbs versus Las Vegas Metropolitan Police. Much like the situation in Stubbs where the attorney argued that his actions were meant to represent his client, that he did not mean to interfere with the official duties of the officers, appellant makes a similar argument in his intent to merely exercise his First Amendment right to video record officers and not to obstruct. However, the Ninth Circuit wrote in Stubbs points to no case, and we are unaware of none, holding that the right to counsel authorizes, and so it's a right to counsel, number one. Number one, stand shoulder to shoulder with police. Number two, during a traffic stop. Number three, while armed. Stubbs is not the right application of law. And then here, although the state recognizes that some of the specific facts in Stubbs differ, like I didn't have a gun, and the overall principles remain the same, no, they don't at all. Because now remember, in Wilson versus First Judicial Court, it says clearly that I have to have the intent to hinder, delay, or obstruct. I don't. I'm a First Amendment auditor. I don't police. Now I'm going to get into more things because then it goes down to quote
magic wand. Just that magic wand argument again.
Yeah, it's so rhetorical. It just sorry. It just
and again, Zimmerman sniffed his intent out early on, and that's why he's where he's at.
And she managed to define it and be done with it in less than 5 minutes.
Yep.
And
here we are like dummies.
Yeah, we're on the 12th video.
It's our own fault, folks.
Yeah, it is. Yeah, this is self-infliction.
This is kind of fourth paragraph down, page 8. Glick versus Cunniff, to advance his argument, he was inappropriately arrested for filming the officers. However, Glick is distinguished from this case because the individual filming was in no way interfering with the officers. I wasn't interfering either. How is telling the cop, go get in your car and write your ticket, little doggy? How is that interfering with him? I told him to go do his job. I didn't tell him I'm going to punch you in the face if you go back to your car. Those are fights.
Just the simple fact that there was an argument taking place which took the officer's attention away from the car stop, period.
Yep.
I mean, I'm all for freedom of speech, but this is not a blanket constitutional right.
And it's Chille DeConner just pointed out. Yeah, there's a significant straw man element to all of this.
Shit, I guess I need to go turn the comments back on.
Fighting word. That's also mentioned in Wilson versus First Judicial Court. It says that fighting words are protected unless you're using direct.
You're right.
Next paragraph down, page 8. The difference here is the appellate was actively interfering and obstructing. No, I wasn't. And it's clearly defined by the Nevada State Supreme Court.
It wasn't. None of what he said.
I'm not obstructing because of where
none of his language, or any of that really played any significant role in any of the court proceedings. So this is, again, just straw manny.
Nothing. I felt so sorry for that Orem when he came in. He was trying to catch up with what was going on.
Well, I'm sure the very large check he got.
No, I'm sure.
He's
I'm
just,
sure. But after watching it a
he's
couple
troubled
times,
mind.
you could see that he was really scrambling to try to figure out everything that really happened. He only had
Oh
13
yeah,
pieces.
and well, you could see the moment he just
Right.
his body language. You could feel it through the video.
Yes, Your Honor. Mr.
It just
DeCastro,
needed-
why do you have a YouTube channel?
You just hear
yes,
that.
Your Honor.
Wah, 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 trumpet, or the slide whistle.
I'm standing over 10, 12, 15 feet away as I slowly backed up foot by foot by foot.
You
It's
lied,
absolutely
motherfucker.
ridiculous. And then it goes on to quote State versus Beckham on the second to last paragraph. A person must not be detained longer than necessary, and this is no longer than 60 minutes. So Bork had 60 minutes to tell the woman, come back to my car and let me deal with you here, because she doesn't have any expectation to privacy in public. Here's where the lies really begin. The very last line on page 8 into page 9. Listen to this. And this is for the traditional media. It's me right now. It could be you next. However, appellant's conduct, which is seen on the body-worn camera, was preventing Officer Bork from carrying out his official duties in an orderly and safe manner. Really? By me standing there and filming him, telling him I'm a member of the press and go do your job, little doggy, that somehow obstructed him from doing his job? That's for...
Yeah, and that takes me back to a few live streams ago when we were watching a couple things, and I went to that chase, and that chase went on for 6 or 8 hours, and it ended in a crash in LA. And there's 3 reporters on the scene, all standing about 20 feet away, and they're walking around and filming, and they're paying no attention to them because they're not interrupting.
Yeah, they're not
police.
inserting themselves into the
They're
middle
not.
of
That's right. And we all know that Chille has to insert it. All of them do, but Chille has to insert them. So
preposterous. Now on page 9, here's where the lies really double down by Wolfson and Chen. Appellant was incredibly aggressive and argumentative with Bork. In which way was I incredibly aggressive? I was the only one who had my head on straight that day. The rest of those cops were violent and hurt me. I had surgery on my hand for what Sandoval did to my...
Oh, wait.
He said I had my head on straight that day. That's
He's the
the
only
problem,
one,
Chille. Yeah, that's the problem, buddy. When your head's on straight, it is convoluted and twisted.
Did you just say he had to have surgery on his hands because of it?
He did.
That's what it sounded like. Scoot back about 10 seconds. You missed it, Linda. How did you miss a car chase?
No, she was here. Yeah, I went to the end.
No. She's saying a 6-hour chase, and I missed it.
It was at the end of it. God dang it! Where were we, bro? Right there, I think.
Should be revoked. Appellant instead argued with him and excitedly told the officer he was not required to move. Excitedly? The wind is blowing at 25 miles an hour.
You got to go
It has
back
to
a
be
little
to be
bit.
heard.
Go back a little more. Start there.
That day. The rest of those cops were violent and brutal and hurt me. I had to get surgery on my hand from what Sandoval did to my
Yeah, he just said he had to get surgery on his hand.
incredibly aggressive. In which way? The wind was blowing about 20, 25 miles an hour. You had to raise your voice to be heard. And all I could do was
Now,
go get this car.
I don't know much about hand surgery, but when I smash my foot up, and your hands, you're like your feet, they're primarily just bone and bone. Hand surgery and foot surgery leaves it takes a long time to recover from those if it's anything serious. So that's a lie right there. I mean, if he had hand surgery after this, there would have been evidence of such hand surgery. He also would have endlessly complained
about it. Yep.
Yeah. So he's a liar. There you go. As if we needed any more evidence. But
Those are stress testing my First Amendment right. I'm a First Amendment auditor. And then Chen and Wilson go on to say, again, the issue here is not whether appellant had the right to film the encounter. Bork even told him he has the right to do so. However, appellant did not have a right to ignore or resist the reasonable commands that Bork gave him to record from a reasonable distance from the traffic stop. Even appellant himself testified he was only willing to back up a couple of feet because he felt it was sufficient distance by his own standard, not by my standard, by every single state across America. That's the reasonable distance is 10
Oh,
or 15
wait.
Moreover,
Didn't he
rather
just
than
say, now he's saying every state in America has, what the fuck is this guy?
saying the reasonable commands, those were not reasonable commands. He's not my dad. I am a member of the press. My
here
job
we
is
go.
yeah,
Wow.
yeah, we love that one. You're not my
Holy
daddy.
shit. Yeah,
Where
this
did
is
Hoyt?
where
Where did Hoyt get that? Yeah,
This
I'm
is
your
where we
daddy.
get-
I'm your daddy.
get
force
into
the
the
state and
deep
hold police accountable
therapy.
to film them. Had Bork been beating on that woman or killing her, I would be deemed a hero today. But because he wasn't, then, then my press rights should be revoked. Appellant instead argued with him and excitedly told the officer he was not required to move. Excitedly? The wind is blowing at 25 miles an hour. You have to speak up to be heard. Instead of physically moving an adequate distance, I was already an adequate distance away. Appellant instead told the officers to go get in your car, little doggy, and write your ticket. So how did that stop him from doing exactly what I said? The result of the appellant arguing and refusing to obey the commands was that Bork's investigation into the traffic infractions was being willingly hindered, delayed, or obstructed. No, it wasn't. No, it was not. I was willingly doing my job as a First Amendment auditor. I had no intention to hinder, delay, or obstruct whatsoever. It's preposterous.
Does
Okay.
he bring up the emphasis, the infamous Rodriguez versus United States?
I don't know, man, but this is, I dropped out. I stopped watching slightly before this, so this is all starting to.
Yeah, I didn't watch this one at all.
I have a feeling I may have to do my one allotted scream into the ceremonial pillow before this is.
This whole thing is just full of lies. Now I'm on page 9 here. Second to last paragraph. Furthermore, although appellant believed that his actions did not amount to obstructing an officer, appellant admitted on the stand he did not exactly know the statute or language. You know what? It doesn't matter if I do or not because the statute or language has been clearly defined in Wilson.
Oh, now it doesn't. It just doesn't matter.
No, it doesn't matter because he's going to make up shit and lie anyway. So
because it's me, yeah.
It's me. That's right.
For this case, and now they do. Obstruction is a physical act. That's what the Nevada State Supreme Court said. And by the way, that's misquoting me. I didn't say I didn't understand. I knew exactly what the law was. Appellant said Officer Bork's commands were unlawful because he's only prohibited from physically interfering with the investigation, which is exactly what the Nevada State Supreme Court said. So I'm going to jump ahead a little bit here. There's a couple more things I wanted to cover, but I've already covered them. So now I'm on page 10 here.
A couple of things I want to cover, but I've already covered them.
And watch the video of the body-worn footage. Appellant resisting his arrest. Appellant refused to go in front of the officer's car. That's not true. I led the officer 30 feet back to his car. Then last paragraph, appellant then struggled with Officer Bork. No, I didn't. No, I didn't. I understand. I have no intention to ever fight police whatsoever. I didn't struggle with him at all. If it was a fair,
but I could totally kick his ass.
There wouldn't have been a struggle at all whatsoever.
There you go.
That's just a simple fact. But that's not what I did. This is a lie. Chen is lying and Wilson is lying. Appellant then struggled with Officer Bork. No, I did not. No, I did not. I've wrestled for over 30 years of my life. My job is not to wrestle police on the scene. My job is to film the interaction as a First Amendment auditor. I have no intention ever to have a wrestling match with a copper. Ever. Whatsoever.
But I could totally kick his ass.
They're lying. And then here, it said, appellant admitted on the stand that he swiped at Officer Bork. No, I didn't. Did not. Put my hand up to block his hand from hitting my face. Officer Bork actually testified that he did not believe in any way, shape, or form was I trying to fight him.
So he's objecting to the word swipe.
They're lying about me. This was not what was said on the stand. You can get the transcript yourself. I did not admit that I swiped at Officer Bork. A hand was coming at my face. I put my hand up to block my face. His hand hit my hand. My hand was less than inches away from my face. Protect yourself at all times. So then it says, it goes on to talk about resisting, but I want to get a little bit into the judicial bias here. There's several pages that I marked up here.
Let's.
And I'm not going to talk too much about the judicial bias because there's.
Okay, he's all fired up about this, right? Okay, July 10th comes around, and then this is what he'll look like on July the 11th. Everybody remembers how deflated he looked when he was all wrong. This is the way he's going to look after July the 10th. There's no doubt in my mind. He's so fired up about this. All he's doing is setting himself up for the biggest letdown of his life. I really believe that.
Yeah. At this point, watching this guy, I just feel like I'm doing penance for some unnamed sins, unknown, and
Yeah, karma's caught
some
up
sort
with
of
you from
karmic,
something.
yeah.
You start thinking back.
Litigation, I will be filing a lawsuit for what happened. But I
Oh, that's right. That guy I flipped off the other day. Yeah.
want to talk about a couple of things here. They continue
No,
to
it would have
press
been something really bad.
how appellant cites various incidents. There was no basis for the justice court's disqualification in the appellate case. Appellant cites various incidents that occurred during the proceedings to support his self-serving argument that the justice court was biased against him. His argument of judicial bias lies in the justice court asking him to empty his pockets to ensure that he was not recording the proceedings. That's not true. You can hear it yourself in the channel called Dawn during investigations. The bailiff came over and harassed me before court for a good 5 minutes and then went back and had a talk with the judge. Then the judge came out and said, I'm not going to be a part of your YouTube channel, meaning that she had already formed a bias against me. And then the judge and the bailiff colluded together and she said, let's search him before the trial begins. That would trigger me. And that's what I'll be doing.
I think it just means she didn't want to be in the middle of a bunch of bullshit, Chille.
She had
He insists he in his mind, she went, watched his whole channel and was obsessing on him and like was just determined to fucking grind him into the carpet. I mean, please. She sussed you out in about 5 minutes. She was aware that you have a stupid YouTube channel and this is your grift. Knew it and just was shutting it down. End of story. Right? You're muted, Ram.
Urged me. I already went through the metal detectors. I'm no threat to anybody. And then it said, appellant did not seek. And then, of course, it goes on to say how I called the bailiff a pig. He argued he was chastised by the court because it called the court martial a pig. I did call the court martial. I did call the marshal a pig because he behaved like a pig. He treated me unjustly. He treated me like a bully before court began. And then when he came over to illegally search me, he was jerking my pants pockets out, ripping my jacket around. And then it said,
He really sounds sorry about it, doesn't he?
To have the justice court removed from his case, disqualifying the judge's waived by failure to timely assess that a court should be removed. That's not my job. That's my lawyer's job. He should have immediately called for a mistrial. The moment she said, I'm not going to be a part of your YouTube channel, the bias was clear. The moment she had the bailiff search me, the bias was clear. I'm not a trained lawyer. So that's why we put in here for ineffective counsel as well.
Here's your constitutional law scholar.
But it says that the court convicted me beyond a reasonable doubt. You mean the biased judge convicted me? No jury? And then she put me in jail? There's going to be a payout here. There's going to be a big payout here.
You're the one that wanted to have trial by judge.
Yeah.
You could have had a jury.
And let's not forget, you could have just taken a plea deal and walked away.
Yep. And we'd be covering magnet fishing.
So now I'm on page 14 here, and I'm just past here. I'm on number 3. Very top of it, there's A, C, D, and then number 3. It says, a judge upon the judge's own motion may disqualify himself or herself from acting in any manner upon the grounds or actual or implied bias. She was completely biased. And in my appeal bond hearing, she even said, have you seen his videos lately? Meaning she was going outside the scope of the case. Judge Ann Zimmerman will face a federal civil
meaning you made a highly inflammatory video that got covered by the local media, let's not forget.
That's true.
That meant name checked her. And was, in my opinion, threatening.
I agree.
Yeah, do you expect her just to be like, "Oh, well, yeah, don't worry about that"? Like that, just not take that into any kind of consideration at all.
Yeah, Chille picking another.
However you like. Go ahead.
Picking another fight that he doesn't intend to fight. Chad Goo, Judge Zimmerman, throw all those innuendos out there, making borderline threats. And I mean,
well, he even said it earlier. He said, it's never my intention to ever get a wrestling match with a cop. Yeah, we know that, motherfucker. You fucking ran like a little bitch from Chad.
Well, even the cop, even Bork. Even Bork, when Bork was arresting him, he goes, okay. He's
Yeah, dude. I mean, is there any more bitch move than like I'm gonna totally kick that guy's ass like after the fact? I mean, and he does it every time. Every time. There's your alpha male.
Will face a judicial complaint, and that's what I can do. And she will face the
Him and
media for
Michael
the rest
Inland.
of her life. So then it goes on to say here, now I'm down here, therefore, I'm just past those little subsections here, and then it goes to the bottom, ID at 650. Therefore, a defendant's bare allegation of bias is not sufficient to overcome the presumption that the court is not biased. It's not my bare allegation. It's plain as day. You can see it on video. Unless they show the judge has closed his or her mind to the presentation of all evidence. Cameron versus State. Well, when we went to the appeal bond hearing, the judge didn't want to hear anything that was going to be presented at the appeal bond hearing by my lawyer, Chris Norum. She said, no. All I wanted to do was say I was sorry for name calling during a legal proceeding, because that's not the place to do it. Even if the bailiff was acting like a pig, that's not.
And you just proved that you're not one bit sorry.
Find justice, not where we hurl insults at one another. On page 17, second to last paragraph, third or fourth line down. Appellant's trial counsel filed a bench memorandum which included law that was relevant to his First Amendment claim. So my First Amendment claim was never considered. She never considered that I was a member of the press. And then it says inclusion here.
Doesn't fucking matter.
The evidence of this case.
Well, not only that, it doesn't matter. But if you remember, the prosecuting attorney said that was just presented to my office this morning, Your Honor.
Yeah, they didn't.
They didn't file it.
Sort of prior notification that he was going to be arguing on First Amendment grounds. But I don't think he would have won in that case either. It would have been a different.
But it's just another point.
Supports the justice case's verdict that the appellant had violated obstruction and resisting. Although appellant wants to make the case about the First Amendment, his actions that day were not at all about individual rights, and instead were a deliberate attempt to obstruct, resist, or the officers, which is completely inherently false. I just want to comment one more thing on the judicial bias part here, where Chen and Wilson are going to try to claim that I agree with the judge. I want to comment on this real fast. So just one more comment here. On page 15 here, when we're talking about judicial bias, Judge Ann Zimmerman says here, and they quote her, "When you say he doesn't wish to engage in wrongdoing, it seems to me from observing him in the video, he wants this. He wants to get arrested. He wants to get in an altercation with police officers. He welcomes this. This helps his YouTube channel. He called the officers here in my courtroom today pigs. He called, and he's nodding his head up and down." And the defendant says, "I agree. I was mocking her because she had run a kangaroo court. She let her run amok from beginning to end. There's problems in here." So just so you know, before the trial began, the first bailiff came up and decided to mess with me, and then the second bailiff, his sergeant or whoever she was, came up.
So here's how Chille's ego really. This is how dumb this guy is. He has an opportunity to say here instead. When I said I agree, I was just talking about the agreeing about the part. You know what I mean? Not about it helping my YouTube channel, right? I was just agreeing with the pig part, right? Me saying pig. I'm not agreeing with it. Instead, he said, I was mocking her. Like that's you know what is the number one winning legal strategy is mockery. I bet you guys didn't know that.
Yeah, mockery.
He has to put on. I mean, his tongue. He just has to continue the posturing.
That's why the soft-sits have such a good record in court, right?
Yes, he was hoping his withering sarcasm would just slam dunk his case. Yes. You know, his sentencing. It was just the icing on the cake. What an idiot.
Not true, unless of course they conferenced before the court trial began. Because I called the bailiff who snatched the phone out of my hand and searched me, I called him a pig. But the other little copper in there, any interaction that was done with her was done before the trial began. She was biased from the very beginning.
Honestly, it doesn't matter. A bailiff is there to secure the courtroom, whether the judge is on bench or not. That's
Yeah.
their job. I can tell you that. I know firsthand that's your job.
Well, the judge wasn't in chambers earlier when he was having that conversation with Chille. Did we play that phone call, the supposed recording from court? Was that on Chille's channel? Did he upload that eventually from the Andre guy? I think he may mention it
in this video.
Maybe.
Mocking government because she's testifying for me. When you say he doesn't wish to engage in wrongdoing, when you say he doesn't wish to engage in wrongdoing, I'm a First Amendment auditor. I'm not engaging in wrongdoing. I'm engaging in filming police interaction. That's my job as a member of the press. That's what I do. That's what I do for a living. I film police. Just like someone runs out to get a soup, whether there's an earthquake or a bridge that collapses, or some famine, or some disaster from a tornado, what I do is I film cops. You say he doesn't wish to engage in wrongdoing.
Did he say run out and get some soup?
I don't wish to break the law.
Can you just go back? Because
no, that's what he said. And then the next line was a disaster in a tornado.
I just want to
be sure. Runs out to get a soup, whether there's an earthquake or a bridge that collapses.
Maybe maybe it's suit, not soup.
But what that?
Because she's testifying.
Huh?
That doesn't make any sense either.
No.
For me.
Chille.
When you say he doesn't wish to engage in wrongdoing, I'm a First Amendment auditor. I'm not engaging in wrongdoing. I'm engaging in filming police interaction. That's my job as a member of the press. That's what I do. That's what I do for a living. I film police. Just like someone runs out to get a soup, whether there's an earthquake or a bridge that collapses, or some famine, or some disaster from a tornado, what I do is I film cops. You say he doesn't wish to engage in wrongdoing. You're exactly correct. I don't wish to break the law. I wish to be engaged in a First Amendment protected activity. He wants this. He wants to get arrested. Well, to the court. I have over 500 interactions with police. The only place I've ever been arrested for filming cops is in Las Vegas, Nevada. And I don't want to.
You weren't arrested for filming cops.
At this point, she's making a mockery of the court. She's running a kangaroo court, like a clown, like an absolute clown. And so I have every right then to mock her and say, okay, I agree. She's up there testifying on my behalf. It's a joke at this point. Clark County will have to pay me out.
Well, I agree with you there.
I wish she could get fired. And he's called my officers pigs. Your officers? It's a joke. This entire response.
They are her officers in that courtroom.
Yeah, they are.
That's right.
It's funny.
When you're a bailiff,
scoop. Maybe running out to get a scoop. Yeah,
no,
it doesn't.
I thought
somebody was saying it's not soup, scoop. Maybe, I don't know. Either way,
it sounds like soup to me. Because then he said, he says salmon. You know,
I think he may have said famine, but either way, none of it made any sense. I mean, it was quite incredible.
Okay, it's word rhyme.
Yeah, I'm gonna have to do like an out of context edit, just taking bits of these phone calls and just putting a montage together, just out of content text stuff that he says, because I have a feeling it would be a little bit like some kind of ayahuasca or acid trip listening to it. Because, sometimes if you take like a heavy, believe me, all this talk is from long in my past too. I like my brain the way it is these days, such as it is. But
damage is done.
In the experimenting I did with psychedelics, sometimes it gets to be a little bit like the teachers and the Peanuts. They did a good representation of that in The Simpsons when Homer eats the Guatemalan insanity pepper and he's talking to Mrs. Krabappel, and then she starts talking like with the muted trumpet. And that's all you can hear. If people are saying things, or you're having a conversation with somebody and you're having the conversation, but you really have no idea what the hell you're saying, but you're or what they're saying. That kind of thing. Anyway.
My appeal is a joke. Chen and Wolfson lie in this over and over and over. That copper, when I said, go get in your car and do your job, little doggy, he could have done exactly that. Police officers on any scene are supposed to be able to take a certain amount of significant pushback from the public. There's two specific words I can't remember off the top of my head. So if you're the traditional mainstream media, and you're listening to this, when they came for the communists, I said nothing. When they came for the socialists, I said nothing. When they came for the trade unionists, I said nothing. When they came for the Jews, I remained silent. When they came for me, there was no one there to speak up for me. We want to go back to the Sedition Act?
Wow.
And
Wow.
Wow. And you want to have those kinds of things upheld? Well, if you
Jesus
allow Wilson and
Christ.
Chen to print these kinds of lies, that I angrily
Nelson
and that I
Mandela.
excitedly said these things to the copper. No, I didn't. I didn't angrily say anything. I was never mad. Over 500 face-to-face interactions with police. You've never seen me get mad one time, ever.
Oh,
I'm
yeah,
allowed
never.
to redress government in any form I choose, as long as I don't use fighting words. So if the mainstream media, the traditional media, the kept media is going to remain silent on this, who's going to speak up on a deal?
They just don't care, Chille. It's just not that. If it was 10% as important to them as it is to you, they still wouldn't say anything. 50%, 60%.
Yeah, and oh man, just the comparison again to something. I mean, wow,
Fucking egomaniac.
just sickening, man.
It is disgusting. Like I said, and do you think it's smart that he's reading this on his channel?
You know, who knows, man? At this point, you know, I don't know. I mean,
would you? Would
yeah,
you?
No,
I mean, would you? No.
Is it smart? No, absolutely not. Because who knows if it would get used against him. But
well, I mean, he's got close to 500,000 followers, correct? That's what he said.
But it certainly could be. Yeah, I mean, it's tactically foolish, no doubt. Like, and it's all, like you said, just emotion and ego. Yes, unipod, overt well, definitely narcissistic personality disorder.
Yep. Sociopath. Yep. Mark, check all the boxes. All right. There's only a minute or two left. It's got to end soon. It has to.
My daily update for today, June 17th, 2024. We're 23 days away from the appellate hearing, from the appeal hearing in the district court in front of Judge Michelle Levitt. This case should be overturned. The Nevada State Supreme Court has clearly identified that obstructing is a physical act, and it is protected. Unless you're using fighting words,
again, I'd just like to point out that it actually doesn't. It says quite the opposite thing, and that we established. And Patrick confirmed obstruction is not necessarily physical.
Or anybody else there. I went there to film the interaction. Time, place, and manner is clearly defined. 2:30 in the afternoon, in the middle of a busy parking lot, wearing a bright blue hoodie and announcing out front, "I'm a member of the press." I started filming with 2 cameras by the time the interaction was done. It's preposterous on its face. And Wilson and Chen quoted a bunch of cases that are on my side. These cases absolve me. These cases prove that I'm innocent. You even quoted Wilson here. This is preposterous. All right, I'll let you guys go. Thank you so much for your support.
Yeah, because
thank you for writing me letters, for getting me those iCare gift packages. I really appreciate it. For donating to my GoFundMe's. I really appreciate it. We don't stop under any circumstances, under any condition. Alan, I appreciate you, man. Thank you for putting money on my books. You did it. David, thank you. I appreciate it. Coke Doggy Dog, thank you. I appreciate you, man. So many of you. I got your letters. I got your letter, April. I got your letter, Linda. I got your letter, Carl.
Linda.
I got a bunch of letters here. Keep
that
sending
was
them.
Linda.
Two timing on us.
Walk out of here. 23 days. Put it on your calendar, July 10th. And let me just say something to the court here. If you ban my family and my friends from coming in, listen, you're already getting sued. I'm suing them over not letting my family and friends in the court for my appellate bond hearing, for my appeal bond hearing. They denied my people access to the court, and the bailiff or whoever it was at the door lied and said, "Oh, his hearing has already been heard." No, there was a dozen people standing outside, and 8 of those people are signing onto the lawsuit. You cannot ban people from coming into my public hearing. There's no danger to the court from me. That's preposterous. It's just an absolute despotic government and this dog shit court system in Clark County, Las Vegas. It is absolutely dog shit, led by the kangaroo court queen herself, Ann Zimmerman. So she's gonna have to face a federal civil rights lawsuit before she's done. That's all I can actually do. So, all right, I'll see you guys on the next one. I'm not sorry. I'm not sorry one bit. I'm only sorry that I name called in court. Court is not a place to call names. court is a place to try to find justice and resolve differences. So, all right, I'm going to get this walk out of here. I'll see you guys on the next one. Later, Gators.
What a dick.
Thank you, Draco. Appreciate it. Says, we don't stop either, you nutless wonder. That's right.
Man.
We've been on this guy for a long time.
God, man, he is an exhausting little individual.
Nothing's changed. It's just become more intense. That's all. I mean, when you compare this to the Kate Peter, Josh Abram hearing, I mean, that was
legally
mild. Yeah, mild compared to this. I mean, he's just coming unfeathered here.
Yep. Well, he may end up. I don't know. I just don't know. You bring it. If you don't mind playing this, you might have to edit it out later. I don't know, but I just wanted to quick illustrate what I was talking about earlier. Bring that screen up, Ram.
I'm looking next Tuesday. And I tried a couple of times the last 2 days to get information on Mr. Hatch to see what his condition was and how he's doing. And I can't really come up with anything.
This is the gentleman that got
shot. Right. Thomas Hatch. Right. And his half brother, Eric Kessler, reached out to him. And I get it. I'm not going to push it. I'll ask one time and that's it. I mean, these people are living through enough trauma as it is. Just trying to find out how he was doing. Obviously, it's been 2 weeks from Friday. There's 18 days. So, there hasn't been any news otherwise. So it looks like maybe that's good news and he's going to pull through. But I have no idea. The condition. I mean, he could have been hit in the spine. I just don't know. I just don't know. I was just trying to find any news story, anything that would say he's not in critical condition anymore. I guess if I sat and watched the local news for 4 or 5 hours, they might have a 15 or 20 second snidbit in there, but
doubtful.
Yeah,
sadly.
I can't find it searching. So anyway,
well, I would say that he has a lawsuit against that Hoyt guy. Sure.
Oh, absolutely.
He's homeless. So is he? I mean, and who knows, man? I mean,
yeah, I think people would rally behind him.
I think people would too, but some people just don't have the knowledge.
I'm talking about the financial support, being homeless. For him to
right. If he even bothers to, he might just be like,
yep,
forget it.
Yeah, I think
people react so differently.
His half brother seems to be fairly sharp. He's a hell of an artist. I will say this: his artwork is on Facebook, and so if you have a Facebook account, Eric, spelled with a K, I believe, Eric Kessler. His Facebook page. He's got some really cool looking stuff. Anyway,
yeah, I wouldn't. My only, if you want to go over there and encourage him with his art or just say something brief but nice about his brother. But yeah, I wouldn't pepper the guy with any.
No, they're not talking about it there.
No, I'm just saying if anybody,
his threads don't have it. I mean, you'll notice it right away. I mean, that's why it was just a simple, really appreciate, complimented on his what he said in court and said, support it. And if you have any news you'd like to share, here's, we'd be interested in knowing. That was it.
Right. Yep.
And that haven't been back since.
Gotcha.
Yeah, I'm not gonna bug somebody that's going through that kind of trauma.
No, I wasn't suggesting.
Please take down my comment while talking about this poor man. What?
Oh, I'm sorry. I got you, bro. But I have a tendency to wander away from the chat doing
Oh,
other
yeah.
things.
Yeah. Yeah. Yeah, that guy, well, just, hope he gets whatever resolution he's seeking, I guess.
So that's
I
next
think
Tuesday.
the guy who, Hoyt guy is not fit for society.
What a piece of shit. Makes me sick. Guy just
Yep.
makes me sick.
Yeah. And that that's the thing with Chille. He really just doesn't get how he comes across, I guess. He really believes his own bullshit, and that he has some sort of cloak of invulnerability, being a self-appointed journalist and or constitutional law scholar, that he just gets some sort of free pass, or that has any bearing on
Hoyt Webb, every time he shows up to a place, he hits on all those key points. I am media, I'm a press, I got my little press badge, all that stuff. He thinks that's going to protect him from being a jerk and saying offensive things to people. Yeah.
And he uses the dunce cap. He uses several Chilleisms.
Daddy.
Daddy, all that nonsense.
Yep. That's what makes Chille so scary. Is the fact that he's such an influence over simple minds like that.
Yep. I do consider Chille a public menace.
Yeah, you're right,
And
Dr.
again,
Nimrod.